Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I'm Sherri Doherty, and I'm presenting today with Dawn Nicholson from our Philadelphia office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is Defending Chronic and Pre-Existing Conditions, What Really Works. Let's get started.
So we want to start off by explaining how the Pennsylvania Workers' Compensation Act defines an injury, which might be a bit different than what you're anticipating. The Act defines an injury as an injury to an employee, regardless of his previous physical condition, arising in the course of his employment and related thereto, and such disease or infection as naturally results from the injury, or is aggravated, reactivated, or accelerated by the injury.
The Pennsylvania Workers' Compensation Act is considered a remedial act. The legislature intended it to have a humanitarian purpose, and as such is liberally construed by the courts. So what is defined as an injury in Pennsylvania may be different than what you see in other states that you may have workers' compensation cases. You don't need to have an actual accident or an incident. Prior to 1972, the Workers' Compensation Act required some sort of actual accident or violence to the body to be defined as an injury. But the amendments in 1972 took away that requirement, and things that are an aggravation or an acceleration or reactivation can be determined to be an injury under the Pennsylvania Workers' Compensation Act.
And as Sherri had mentioned, an aggravation could include things like aggravation of a pre-existing back injury or a pre-existing knee injury. We don't often see the phrase reactivation used in terms of an injury to a pre-existing condition or a chronic condition. But acceleration of a condition does show up at times in relation to acceleration of pre-existing arthritis. So an individual may have already had arthritis in their back prior to the work injury, but after the work injury occurs, by diagnostic standards, there has been an acceleration of that arthritis, and that in and of itself can constitute a work injury.
And aggravation can also apply to things like asthma. Somebody may have asthma as a pre-existing condition, but they may be working in an environment that is dusty or something like that that causes their asthma to be aggravated. So that could also be considered to be an injury under Pennsylvania workers' compensation. One of the things that can prompt an employee to file a claim for workers' compensation based on a chronic or a pre-existing condition is when they've exhausted their short-term disability benefits. So if your employer does provide short-term disability benefits and an employee goes out of work, say for back pain, and they're treating with their primary care doctor and maybe referred to a specialist or a pain management doctor, and when they apply for short-term disability benefits, they notify both the employer, their doctor, and the short-term disability carrier that their back problem is a chronic or a non-work related condition. What we see happening is once those benefits are exhausted, the employee may come back to the employer and say, I've been out of work for my back problem, I'm not ready to come back to work, and now I think that my back problem is a work-related injury. We see that quite frequently. So in terms of those type of cases, one of the defenses that we would have is the statutory notice defense under the Workers' Compensation Act. Under the Act, you are required to notify your employer within 120 days of your date of injury. So if somebody goes out of work, say on January 1st, and they're on short-term disability benefits until the end of June, and then they come into their employer and say, hey, I think that my disability is a work injury, one of the defenses that the employer has is that the employee did not provide statutory notice of that injury within 120 days. So that's obviously somebody seeking to get workers' compensation benefits after their short-term disability benefits are exhausted. Dawn, are there other reasons why someone may try to claim a pre-existing or a chronic condition as work-related?
Yeah, we do also see instances where employees become concerned about job loss. This could include something relative to that employee only. Perhaps they have issues with their job performance, or it might be something as widespread as a plant closure. It's not uncommon to see a rash of workers' compensation claims for things like low back pain or knee pain if there is rumor throughout the workplace that perhaps an employer is closing up shop. You could see 5, 10, we've had instances where that has happened, claim petitions filed because employees are concerned about wage loss following the plant closure. So that's also something that can prompt an employee to file a claim for a chronic or pre-existing condition.
We also see that with layoffs, where somebody finds out that people in their department are getting laid off, and they may feel, well, maybe I can receive more money on workers' compensation than I can on unemployment compensation, which rates are usually a little bit lower than the workers' compensation rate. So we also see that with layoffs, where people will come in and say that they have a work-related condition and seek workers' compensation benefits.
So some considerations when defending against a claim for a chronic or pre-existing condition. You want to conduct a thorough investigation, and one of those considerations is what was the employee's level of function and medical treatment at the time that they were injured or that they allege they were injured. So was the employee on work restrictions at that time? Were they actively treating with a physician for a condition? Were they taking any medications? Was there any alteration of their activities of daily living that would suggest that they were having issues not related to a work injury, but to a pre-existing or a chronic condition? So one of the things that we want to do in order to determine what that level of function was at the time of injury is to subpoena pre-injury medical records from the claimant's primary care physician and pharmacy as early as possible in the litigation. There are some judges who will allow, depending on the venue, defense counsel to conduct limited cross-examination for purposes of determining who the claimant's medical providers are, so that those pre-injury medical records can be obtained quickly. More often than not, judges now are leaning away from testimony at pretrial hearings and leaning more towards allowing for a quick deposition of the claimant, perhaps within the first 30 days after the pretrial hearing, so the claimant can be cross-examined for purposes of determining who their treating providers are currently and who they may have been in the past.
Yeah, in my experience, the records from the primary care doctor and the pharmacy tend to differ from what the claimant seems to remember when they testify. Sometimes they have prior medical conditions that they testify they were fully recovered from long before their alleged work injury, and then we get the primary care doctor records showing ongoing treatment for the same body part, and then we receive pharmacy records showing that they're still on the same medications from an injury or a medical condition that they had, that they testified that they were fully recovered from. So those are good ways to question the claimant's credibility. The other thing that we've been finding helpful is using a hospital canvas, and this is a way that you can find out places that the claimant has treated over the past several years. And this tends to be really helpful because, as we said before, a lot of times the claimants have selective memory and they don't seem to remember all the places that they sought medical treatment, or they try to downplay the amount of medical treatment that they've had prior to alleging a work injury. I actually had a helpful situation recently with a hospital canvas where a claimant had a recognized slip and fall at work. He was a very new employee. He fell on both hands and sustained injuries to the wrist as well as a low back injury. He stopped working light duty after a few months and filed a claim petition seeking total disability benefits. We obtained his medical records from the work injury, and he had been seen by a hand surgeon for his wrist pain, and none of the physical examination or the diagnostic tests were revealing why he was having numbness and tingling in his arms. When we did the hospital canvas and obtained medical records, we found out that the claimant had actually been recently diagnosed with multiple sclerosis, which completely explained why he had numbness and tingling in his arms despite negative diagnostic studies to the wrists. So that hospital canvas allowed us to get those records very early in litigation. We got a favorable settlement to the claim before we had to spend money on taking depositions, getting an independent medical evaluation, and scheduling medical depositions. So that was a situation where very early thorough investigation into claimants' other medical conditions was really helpful in limiting a claim.
And there may be instances where a provider, such as a primary care physician, requires that the claimant sign an authorization before they'll agree to release those records. If the claimant objects to signing that authorization, defendants have a couple of options in their arsenal in terms of defending against those claims. One of those options is to object to the deposition of the claimant's medical expert until those medical records are produced. As long as you timely object to the deposition, the judge will most likely sustain the objection. Another option that you have is requesting that the judge draw an adverse inference against the claimant. So what that means is, while in some cases there may be a presumption that the claimant has sustained a compensable injury, if they fail to produce relevant discovery, the judge may find that it is appropriate to draw an adverse inference against the claimant for failure to produce those records. That can be very helpful from a defense perspective in ultimately defending against the claim. And finally, this is something that we tend to do as a matter of course, but when we send the claimant for an IME, we do ask that the IME physician hold his final opinions until he's received all relevant medical records. So we'll ask that they render a tentative opinion to be finalized only once they have received the remainder of the medical records.
Right, and that's a timing issue we have based on the scheduling orders provided to us by the workers' compensation judges. Under the judges' rules, it provides for the IME to be conducted within 45 days of when claimant testifies, and depending on the judge's schedule, that can be rather early in the litigation. So a lot of times when we're required by the judge to have that IME completed, we still have quite a lot of records outstanding. It's very common for the claimant's attorney to send us only records of the providers that the claimant sends the claimant to, or that the attorney sends the claimant to. The claims adjuster usually sends us the panel physician, your work nets or your concentras. And so a lot of times the records that predate the work injury, or things like the panel or the primary care doctor or any emergency room records, are received much later. So we want to make sure the IME physician is aware that there is a pre-existing condition, there's a chronic condition, there's prior motor vehicle accidents or prior work injuries, that we are attempting to obtain those records, and that we would like the doctor to hold off on their opinion until all those records are received.
One of the other things that we do request often in investigating claims is the personnel file of the employer. So what we're looking for are things like, how long had the employee been working for the employer at the time of injury? If the employee had only been working for the employer for, say, 1 or 2 weeks, or even as short as 6 months, that may be relevant in terms of defending the claim. Did they intend to be a long-term employee here, or were they just simply hopping from one employer to another as a result of work-related issues? Also, what was the employee's job description? What were their physical demands? What was their prior employment history? And again, this goes into what types of jobs were they performing prior to working for this employer? Were they laborious jobs? Were they sedentary duty jobs? Is there a suggestion that the claimant was previously retired and then chose to re-enter the workforce? We had a case where there was a state police officer who had worked for 35 years as a state police officer and then retired as a result of back issues. He then chose to re-enter the workforce and work as a part-time security guard. When he was cross-examined, he never revealed the fact that he had been having back injuries, and that had basically factored into his decision to retire. So obtaining those employment records and those pre-employment records was very critical in defending against the claim petition.
And then there's a lot of things that you may find out from the employment file that may form a basis for why the claimant may be looking to get out of this job. Was the employee in a progressive disciplinary action at the time of the alleged injury, or was excessive absenteeism an issue? If an employee feels that they are on the verge of being terminated for any reason, they may seek to file a workers' compensation claim as a way to get out of this employment situation and get paid for being out of work. You want to investigate with either HR or a supervisor if the employee has a positive or negative reputation at work. That could form a basis for filing a workers' compensation claim, and also could help you in determining where you want to go with the case. Is this a employee that you want to get treated and bring back to their pre-injury position, or is this an employee that the employer just does not want back at this employment, and your goal in litigation would be to be in the best position to settle the case with a resignation?
One of the other tools that you can use in helping to defend against a claim is an ISO claim search, and that will reveal prior work injuries as well as motor vehicle accidents.
For prior motor vehicle accidents, you want to determine if somebody has prior bodily injury claims, the type of injury, and whether litigation resulted. In workers' comp, we see a lot of people that we call frequent flyers. They either have a lot of workers' compensation claims, a lot of motor vehicle accidents, or a combination of both. What we want to do in the situation is take a careful look at the ISO claim search, determine which prior injuries may be relevant in investigating the current claim. You can subpoena the insurance carriers that are identified on the ISO. If there's prior work injuries, you can subpoena employment files from prior employers. Sometimes even medical providers are listed on the ISO as places that they treated for motor vehicle accidents, and you can subpoena those records as well.
Excuse me, you may all want to, sorry, I'm a little choked up right now. I apologize, I'm going to ask Sherri.
Right, so if somebody has a pre-existing condition that was a prior work injury, you want to look and see whether there was a separate employer and or a separate carrier for that prior injury. If you have a separate carrier from a prior work injury that the case was already settled, you can use that as an argument in litigation, but we would not recommend pursuing a joinder petition against another employer or carrier that has already settled out their liability to that particular claimant. If there is no settlement, a joinder petition may be appropriate, arguing that the other carrier is primarily or jointly liable. So under the Workers' Compensation Act, there is a time deadline for filing a joinder petition. You would need to file your joinder petition within 20 days from the hearing at which evidence was presented to support a joinder of another employer or insurance carrier. You can file it later than that, and it would be up to the judge's discretion as to whether to allow you to pursue a joinder against another employer or insurance carrier. There's also, the judge has the ability to find or to apportion liability against two employers or carriers if the judge finds that a portion of the disability and medical treatment are related to a current injury versus a prior injury.
The judge may also consider the timing of the second injury in relation to the first injury. So was the claimant still treating at the time of the second injury? How long before the second injury occurred had the first injury occurred? Were they taking medications? Were they still under work restrictions? Were they attending physical therapy? All of these are things that might suggest that the alleged second injury, which may be nothing more than an aggravation, is in fact a continuation of that initial work injury. You may also want to consider whether the alleged aggravation or injury has given rise to other potential third-party liability claims that would present an opportunity for the carrier to seek subrogation. This would be especially true in instances of motor vehicle accidents or assaults, something that would suggest that there might be some other party that the claimant could ultimately hold responsible that would help in the long term to reduce your liability in relation to the claim.
So this just kind of goes back to doing a full and thorough investigation at the beginning of the claim. No judge wants to see you filing a joinder petition after you're in litigation of a claim petition for a year and a half, and both parties have put on medical evidence and fact witnesses, and the claimant has testified, and then all of a sudden you're filing a joinder petition. That's not going to be taken well by the judge. So if you feel that there is an opportunity to join in another employer or carrier, the earlier that we can get to that in litigation, the better effect that would have on attempting to reduce or even eliminate your exposure.
Some other tools that are helpful include social media searches. So as we all know, we live in a social media world this day and age. We want to know what the claimant's pre and post injury activity included. That certainly is going to include things like Facebook. It could also include Instagram. Any social media platform that is heavily used might provide an opportunity for additional investigation. It is possible to obtain a court order to view even private Facebook pages. So for instance, some claimants, despite their attorney's counseling, will choose to remain active on Facebook during the litigation of a claim. Sometimes you get lucky and the Facebook page is public and you can view everything that's being posted. At other times, the Facebook page has been made private and you may only be able to see the profile picture. However, if there is something within the profile picture that seems like it might lead to relevant information related to the work injury, it is possible that the court will grant you an order to get access to the employee's Facebook page for a limited period of time. They will actually be required to turn over the username and password to you. If they were to delete anything that's contained on that Facebook page, that would be considered spoliation of evidence. It's not allowed, of course. It doesn't mean that people don't do it. They certainly do still delete some of their posts and activities. But you will only have access to that Facebook page for a specific period of time. And then the claimant is permitted to change the username and password to effectively lock you out again.
Right. So social media searches does not give you license to do a fishing expedition against the claimant. But if you do obtain good information, it's really helpful to use this to help with cross-examining the claimant, questioning the claimant's credibility. They may come into court and say, oh, since my work injury, I haven't been able to ride my motorcycle anymore, but you see them on Facebook riding their motorcycle or talking about riding a motorcycle, or they say they can't drive, but they just posted on Facebook that they drove from Pennsylvania to Florida for vacation. So that type of information can be useful in defending the claim petition and determining whether they in fact have a work injury or are embellishing things for the court's purpose. You can also do a Google search. This could show their level of pre and post injury community and social activities. Dawn, I think you have some good examples of information that you and your paralegal have uncovered in cases with Google searches.
Yeah, we've had a couple of instances where simply Googling the claimant's name has led to some really helpful information. In one instance, the claimant was alleging severe orthopedic injuries, including injuries to her low back and her legs. But a review of just online posts had made evident that she and her husband were actually running a community center, a recreation center. And she sat on the boards and commissions of several different committees throughout her township. So she was very actively involved in her community despite testifying that she was completely and totally disabled and that her activities of daily living were severely restricted. We also had another example in a mental case where the claimant was alleging that she was suffering from PTSD and anxiety as a result of a dog bite, but a social media search, Google search actually, had revealed that her family was in the process of a trial, that there had been a traumatic death in her family that was completely unrelated to the work injury, but was certainly factoring into the social stressors on her family at the time of litigation. So a simple Google search can reveal a lot, actually.
One of the other things that we recommend in defending chronic and pre-existing conditions is to perform docket searches. Usually on the civil side, it's not very helpful unless you do find some sort of injury litigation, but normally that would come up on your ISO search. Criminal dockets can be quite interesting if you find convictions in the last 10 years. There's a couple of things you can use them for. One is to attack the claimant's credibility. The other is to determine whether, in fact, they may have sustained injuries while incarcerated. It's very well known that there's often a lot of physical activity and fights while people are incarcerated. Prisons do have medical or dispensaries where the inmates can go for medical treatment. So you may be able to get some records to determine if they treated for any injuries or medical conditions that are similar to what they're claiming in the work injury.
We did actually have a case that was relevant to this. There was a gentleman who had an accepted lumbar sprain strain. He was then incarcerated for, I believe, 5 years. It was a lengthy time period. And after his incarceration ended, he filed a review petition alleging that his work-related injury actually involved herniations at multiple levels of his lumbar spine. His MRIs prior to incarceration, interestingly, were effectively unremarkable and showed only age-related degenerative changes, whereas his MRIs post-incarceration showed severe herniations at multiple levels of his lumbar spine. It can be difficult to get medical or dispensary records from prisons, but it is certainly worth the effort if there is, as was suggested in this case, something that happened during that time period that was not the result of the work injury, but something that may have happened while the claimant was incarcerated.
And then, of course, you always want to include surveillance in your investigation of a claim. Does the claimant's post-injury activity support his or her argument for disability? You want to also want to look and see if we see them working. There are people that return to work in an under-the-table type capacity or working for a friend or family member that they may not really consider to be employment, but does show their ability to engage in the workforce.
We do also see a lot of home-based employment now, with more people being able to sell products that they make themselves on platforms like Etsy, Facebook, eBay. So that sort of lends into surveillance and social media searches as well. Are they, or do they have some alternative form of income that they're not disclosing, as Sherri was saying, effectively under the table?
The other thing we want to look at is claimant's Social Security and Medicare status. So sometimes you have an individual who is already on Social Security and disability and Medicare when they are injured at your employer. So one of the things you can look at is when did they last work prior to being employed by your employer? What prompted him or her to enter the workforce? Because you do have individuals that, for financial reasons, or maybe they're just bored sitting at home on disability, they go out and get a job. And as soon as they get the job, they're alleging some sort of aggravation of their pre-existing condition. So you want to find out what they're on Social Security for, what type of activities they were engaged in before returning to the workforce, where they worked when they were last employed.
And we did have an instance where there was a gentleman that had been on Social Security disability for a number of years due to psychiatric illness and attempted to re-enter the workforce as a delivery driver. He sustained a work-related injury as a result of a motor vehicle accident. And then years later, when we were prosecuting a termination petition, asserted that he was still having ongoing orthopedic injuries, while the IME physician determined that his examination and medical records didn't support that argument. He certainly was still disabled as a result of his psychiatric illness, which was underlying and non-work related. So you may have instances where the true cause of disability is something other than a work-related injury, and that can only be determined through a thorough investigation of medical records.
In addition to the Social Security and Medicare status, if the claimant is receiving short or long-term disability benefits through the employer, you also want to request through subpoena their records from the disability carrier. In most instances, a short-term disability carrier will not pay disability benefits if the employee alleges that their disability is related to a work injury. So I have a case I'm working on right now where the individual was out on short-term disability for 6 months. When those benefits were exhausted, she filed a claim petition alleging that her back problem was a work-related repetitive stress type injury. We subpoenaed records from her short-term disability carrier, and she did notify the carrier that that her back problem was not a work injury, that she did not believe that her work activities or working conditions contributed to her back problems. She submitted medical statements from her primary care doctor and from her physiatrist indicating that her back problem was not a work-related injury. And now, months later, she's trying to allege that this is a work injury. So we can utilize those records to help cross-examine the claimant and her medical providers to indicate that at the beginning, when she first went out of work last year, that she was not claiming this was related to a work injury.
So pulling it all together, all of the things that we have talked about today, ultimately, the adjuster and defense counsel will need to work together very closely to perform a thorough investigation and to obtain all of the information that we've talked about. Did you want to?
Sure. So it's the defense counsel's job to strategically use the information that we have obtained when deposing the claimant, the fact witnesses, the medical experts, because as you know, the cases often come down to credibility determinations. The judge is going to listen to the claimant, review the medical depositions, listen to any fact witnesses, review any documentary evidence. They may review surveillance evidence, Facebook posts, and it comes down to who the judge finds more credible. And in these situations, it's very important to have the thorough investigation so that we have sufficient information to put before the judge that this disability is due to a chronic or pre-existing condition rather than a work injury.
It's also defense counsel's job to ensure that all of the relevant evidence that we've obtained is actually admitted into the record. There are numerous ways to get that evidence into the record, but it is defense counsel's job to make sure that it does get into evidence so that it's usable, so that it's in the court's consideration. We also use the evidence that we get through our investigations as leverage in settlement negotiations. Our ultimate goal here is to drive down the value of the claim as much as we can. So certainly if we have evidence that undermines the claimant's credibility, that is going to help reduce our ultimate exposure in the case. And finally, if settlement isn't possible for whatever reason, or it's simply not desired by the client, we can use that evidence as part of our brief. We weave that into a persuasive argument. We are telling a story, essentially, and so we want that story to be as favorable to the defense perspective as we can. So in conclusion, we'd like to thank you for attending our webinar, Defending Chronic and Pre-Existing Conditions, What Really Works. You can learn more about this program and all of the other Weber Gallagher events at www.wglaw.com/WG-University. Thank you so much.
Thank you.